My name is Alli Gerkman. I'm the Director of Educating Tomorrow's Lawyers at ILS, the Institute for the Advancement of the American Legal System at the University of Denver. And I'm going to start today by talking to you about the problem. 23%. This is the percentage of practitioners who believe new lawyers have sufficient skills to practice. This is from a recent Barbary survey. 45%. This is the percentage of law professors who believe that new graduates have sufficient skills to practice. 71%. This is the percentage of third-year law students who believe they have sufficient skills to practice. And whenever I present this, usually there's a bit of a chuckle in the room. But this is actually a pretty serious slide, because this slide gets to why this problem matters. These students spent 3 years of their lives, when they could have otherwise been doing some other kind of gainful employment. Not to mention, they made a financial investment of anywhere from probably $100,000 to $250,000 to get an education that they thought might give them the sufficient skills to enter the profession that they sought to enter. So it's not totally crazy that 71% of them believe they have sufficient skills, but it is a real problem that 71% is so far afield from where practitioners think they are. This problem affects not only students, but it also affects legal employers. It affects the bar as a whole. It affects the courts. And most importantly, it affects clients. So I'm going to tell you about a state that ran into this, New Hampshire. New Hampshire had a lot of concern that its graduates were not actually ready to go out and represent clients. To deal with this, what they decided to do was form a committee that included members of the judiciary, it included members of the profession, it included representatives from the law school in the state. And they hammered out a program that sought, at least, to produce lawyers who were client ready. The program is called the Daniel Webster Scholar Honors Program at the University of New Hampshire. It takes the second and third year of law school and prescribes a curriculum that students go through. It's highly experiential, and it also has a very different form of assessment than most law school classes. Most law school classes, you forge through the material, and at the end, you take an exam, and maybe you remember the material later, maybe you don't. In the DWS program, you actually receive formative assessment. And formative assessment is where you learn something, you apply it, and you receive immediate feedback on your performance. So students are able to hear what they did right, what they did wrong, and use it the next time around. They build on what they've learned each time. They receive the formative assessment from their professors, from other lawyers in the community, from judges, and from each other, and even from themselves through personal reflection. Ultimately, they also receive assessment by bar examiners who evaluate the full 2-year performance, their full 2-year performance in the DWS program, and admit them to the bar based on the full 2 years and not based on a 2-day bar exam. At ILS, we decided to evaluate the program to see if it really was achieving its goal. What we found was that, in fact, as third-year students, the DWS scholars were outperforming lawyers who had been licensed for up to 2 years. And here's how we made that determination. We looked at something called the Standardized Client Interview Assessments. All DWS students do these in their third year, and New Hampshire had some non-DWS lawyers who'd been licensed for up to 2 years do these interviews as well. The interviews take an actor and train the actor to actually act as a client and to evaluate the student or the lawyer based on 2 major areas. The first is an overall assessment. So this is about how they felt with the lawyer. Were they comfortable? Did the lawyer listen? Would they actually go back to that lawyer if they had a new legal problem? DWS students outperformed the non-DWS lawyers who'd been licensed for up to 2 years in a statistically significant way. Similarly, they were evaluated based on the amount of information they could actually extract from the interviews. So we all know that when you interview someone, they don't come to you with a checklist of every relevant fact to the case. You sometimes have to dig it out. And so the actors had facts that they knew, but that they wouldn't actually reveal unless they were asked specific questions. So again, in this category, DWS students outperformed non-DWS lawyers in a statistically significant way. So we ultimately declared, with the title of the report we did on this, that DWS scholars are ahead of the curve. And they're ahead of the curve, we said, for 2 major reasons. One is that interesting combination of experiential education and formative assessment that seems to do a really good job of teaching and preparing law students. But the other reason we think this program was so successful is because of the collaboration. This was heavy-duty collaboration from the very beginning. When the judiciary raised this as an issue, you had the judiciary, you had bar examiners, you had lawyers, all involved with the law school in creating this program. They're involved with the law school in actually executing the program. They serve as adjuncts, they provide feedback, and in the end, too, they continue to be involved with the program in that our focus groups found that members of the profession there really do view DWS grads as ahead of the curve. So when it comes time to think about hiring, that is a factor that is surely coming to mind. When we published this, Above the Law talked about it, and they had a critique. Their critique was this: practice-ready programs are a nightmare dressed like a daydream. They sound good, they should work. There's even some evidence, like this study, that shows that they do serve some purpose. But there is no evidence that participating in a practice-ready curriculum helps you get a job where you can show off all of your practice-ready skills. So I looked at this as soon as I knew it was up there, and I was ready to have a reaction to it. But the truth is, our reaction to it is, yeah, we agree. Practice-ready programs, or client-ready programs, or just programs that are really committed to graduating lawyers ready to enter the profession, whatever you want to call them, these programs may very well do a good job of preparing lawyers. But if the law profession and if legal employers aren't hiring based on those skills that they're building in these programs, then law schools aren't going to do them, and law students aren't really benefiting from them, and they potentially, as is suggested here, don't ever get that opportunity to even demonstrate they have those skills. So at IELTS, this makes us think a few things. First, we really need to get a handle on what the profession needs. We need to ask and we need to listen to what is really needed of new lawyers. Second, we need law schools then to hear that, and we need them to view those needs as at least some of the necessary outcomes of a legal education. And we need them to develop models of legal education that get us there. And finally, to the extent that we do have law schools really making strides in that direction, and I think we already do, and I think we'll have more of that, we need legal employers who are willing to hire based on what they've identified as being so important in entry-level lawyers. All 3 of those goals and objectives are wrapped up in our Foundations for Practice project. We are in the first phase. We are listening to the profession, and we are cataloging what the profession has identified as critical from new lawyers. We did that through a national survey that went out in 37 states. The survey looked to identify the foundations that entry-level lawyers need to practice. And when I say foundations, I mean competencies, skills, characteristics, traits across the board. 37 states distributed that. That was thanks to state bar organizations around the country who made that happen. We ended up receiving more than 24,000 valid responses. This is a lot. We have a lot of data, and we are still sifting through it, but we are more than happy to have it. And just so you have a sense of those responses, we have a number of demographics we're looking at where the demographics seem to be reflective of the profession, but the one I really wanted to share with you is this one. This is the practice setting that people came from. So in particular, take a look at private practice. We have 58% of the lawyers in private practice, and of those, 19% are solo, 23% are in small firms, 10% in medium firms, 6% in large firms, and you can see some of the others over here to the left of the pie graph too. This is, when you look at other numbers in other organizations that are tracking where lawyers practice, this is actually pretty representative of where they are. And here's what we asked these respondents to do. We asked them to take the foundations that we list out in the survey and effectively put them in buckets. This item is necessary in the short term, meaning right as soon as they graduate and enter their first job. This item is necessary, but it can be developed over time. This item is advantageous, but not necessary. And finally, not relevant. We asked them to do that with 147 foundations. They ended up telling us that 77 of those foundations, at least 50% or more of them ended up telling us that 77 of those foundations are necessary in the short term. So we have our work cut out for us. But here's the good news. We think we're in a really strong position to actually take these results and make real change. And the reason, and when I say we, I mean the collective we. And the reason we think that is because as we were talking to state bar organizations while distributing this survey, almost every state, even the states that weren't able to participate for one reason or another, they were engaged on this topic. They were excited we were doing this. They're looking forward to the results. And in many instances, they're already taking some action on their own. They have a committee, they have a task force, they have a commission that is already looking at a lot of these problems. And they're looking for ways to actually bring about change. The other good news is that legal educators are doing the same. We have 37 schools in our law school consortium, and these schools are diverse in many ways, but they are all bound by the fact that they are all committed to graduating students who are ready to enter the profession, to enter their careers, to be successful, to have the skills, competencies, characteristics, traits, the foundations that are so critical to them in their first year. So what we want to see those groups coming together to collaborate along the lines that we saw collaboration in New Hampshire with the Daniel Webster Scholar Honors Program. That kind of collaboration will result in solutions that are right for your legal community, that are right for your law schools, and that can actually bring about some very positive change. So I will tell you, one way to begin in that direction, we hope, is through our conference this year. We have an annual conference this year. It's October 1st to 3rd, and this year it will be focused on the results of this survey. We will present, that was where we will first present the full results of this survey, and we will look to that group to create recommendations for how best to make use of those results and how best to really use them to bring about meaningful change across the country. So that room will be full of legal educators, members of the legal profession, leaders of the bar, and we hope to see many of you there. Thank you.